Hi, my name is Robert Chelle with Chelle Law, and I'm an attorney that assists nurse practitioners with employment contracts and independent contractor agreements. Today I'm going to talk about an agreement that is not an employment agreement or an independent contractor agreement, and that's supervision and collaboration agreements for nurse practitioners. Now, first, this is not needed in every state. So there are some states where nurse practitioners are completely autonomous. They do not need a supervision agreement with a physician. And so this is, you can just ignore this video if you're one of those states. Now, as I just said, in many states they are required. And so let's kind of talk about some maybe red flag areas you need to think about when it comes to that. So when you join an organization, there's going to be, and you're in a state where the supervision is required, there's going to be two contracts. You'll have the employment agreement, and then you'll also have the collaboration agreement. The employment agreement is just between the NP and the organization, just dictates the term of employment, how long it lasts, how you terminate it, what you're paid, malpractice, restrictive covenants, non-compete, non-solicit, benefits. So that's what an employment agreement will discuss. Most of the time, scope, collaboration, supervision, any of that kind of stuff, maybe it's mentioned, but it doesn't go into detail in the employment agreement. You will have a separate document, the supervision agreement, and that will have all of the state requirements. So the nursing board in your state is going to have some law, statute, code, regulations, whatever they call it. Every state kind of has a different way of describing it. That discusses exactly what needs to go into the supervision and collaboration agreement. So what are the responsibilities of the NP? What are the responsibilities of their supervisor? How much contact they have to have? How much chart review or signing off on scripts or any of that kind of stuff is going to be listed in that agreement. Now, most states will offer a model agreement, meaning they're going to have like a blank form on their website that says, essentially, if you use this form and fill it out appropriately, you're all set. And so that's an easy way of doing it. Some organizations won't do that. So you need to make absolutely certain when you're offered a supervision or collaboration agreement that it's covering all of the things that the state is mandating is in there. And you can't just take the word of the organization. Like, I would go onto the board's website, figure out what needs to be in every agreement, or even take their model agreement and compare it to what you're being offered, and just make certain that everything is in the agreement that's necessary. You don't want to get a board complaint or have some kind of problem where your collaboration or supervision agreement was below the legal standard and then get disciplined for it. So don't just take the word of whoever is providing to you that it has all of the necessary components that a supervision or collaboration agreement should have. I did licensing board defense for nurses. I've represented, well over 1,000 nurses before licensing board. This, I probably had one or two cases where this became an issue. So I don't think it's that common, but it's just a good idea, excuse me, for the NP to make certain that the agreement that they are being offered by the employer has all the correct components of it. All right, that's a pretty short video. If you have any questions about a supervision or collaboration agreement, employment agreement, independent contractor agreement, feel free to contact my law firm at the information listed below in the description. And I appreciate you watching the video. All right, thanks. Take care.